for the reason that the meaning of the word liquor itself has changed over time. Liquor, what it meant, my lords, 30, 40 years back, certainly at the time of introduction of the Constitution, is not the meaning which is there in common parlance or the predominant meaning today. So, my lords, my respectful submission to the court is...
One thing is very clear, coffee has not still become liquor.
That's true. That is true. Well,
It depends on who drinks.
There are many liquor substitutes, but it's not liquor under the Constitution.
Otherwise, then we'll have to review what we said about the Attorney General.
I try to make good my point.
well, in fact, my submission will be that liquor definitionally includes all fluids. All fluids. That's one of the primary meanings at the relevant time. And I'll take your lordship to the dictionary meaning. So how your lordships interpret intoxicating liquor will first depend on how your lordships interpret liquor itself.
Intoxicating liquor is a species of liquor.
That's right. I'm grateful to the court. So, my lords, intoxicating is a word which qualifies the word liquor. So, and in my respectful submission, a great deal will depend on that. Because if your lordships take the view that liquor is all possible fluids, then it is certainly possible for us to argue that intoxicating liquor includes all liquors which have alcohol in them. That is, which have the capability to intoxicate, whether they are drinkable by humans or not. But if your lordships take the view that liquor itself means only alcoholic fluids, then attachment of intoxicating to it will certainly have a different meaning, which may indicate that it has to be fit for human consumption. And my lords, in my respectful submission, there are two broad cleavages: pre-synthetics 1990, that is pre-synthetics 2, and post 1990. And what is pre-1990, the meaning of liquor was what I am suggesting the court to adopt, which is also the meaning in Balsara. That is, it's all fluids, and therefore intoxicating only qualifies it to make all fluids which contain alcohol in any form. And synthetic breaks that meaning and form, and post-synthetic, some judgments have already been placed before the court, the meaning changes. And this, my lords, error begins in para 70, if I may respectfully say, error of synthetics is in para 74 of the judgment, which is at PDF page 55. My lords will just have it. It's been shown.
We just saw it in the morning.
Yes. The bottom part, I'll just read it. Lordships will not go to it. The above entry contains words intoxicating liquor. The meaning of the expression intoxicating liquor has been rightly interpreted by the Bombay High Court in Balsara. So, the Supreme Court here goes with the Bombay High Court view in Balsara, not the Supreme Court view. And what does it say about the Supreme Court view, which is Justice Fazal Ali's view? The decision of the Bombay High Court is repeated in so and so. In that light, perhaps the observation of Fazal Ali J in Balsara case requires consideration. It appears that in light of new experience and development, it is necessary to state that intoxicating liquor must mean liquor which is consumable by human being as it is, and as such, when the word liquor was used by Fazal Ali J, they did not have the awareness of full use of alcohol as industrial alcohol. Well, just if your lordships will just come to that page 47, there's something which turns on that. I want to just
para 74, page 54, right?
Page 55 PDF begins at 54 at 55 PDF.
So Balsara dealt with a case of prohibition.
That's correct. But
prohibition for human consumption.
But
alcohol for human consumption was prohibited. Then it was challenged on the basis of Article 19(1)(g), because if you have a complete prohibition, then such product is not available as a raw material for toilet preparation and for another medicinal. Therefore, they struck it down on that basis.
Plus the words liquor and intoxicating liquor both were interpreted in that.
And for Mr. Balsara to have prohibition would have been blasphemous, absolutely, you see.
That is another main aspect.
Of course, Balsara not.
Well, the Bombay Act, if I may answer, well, the Bombay Act contained the entire universe, including spirits of all kinds, my lords, varnish, everything. So the Bombay Act in that sense was the entire scheme of liquor, not just. That's true. It arose in the context of it. That's true. It arose in that context, but the interpretation was of the entire act. Page 55, PDF. 5, page 55, PDF. It appears that in light of the new experience and development. So the.
But can you just now, okay, this we have seen.
Yes.
How do you say that, the definition of liquor pre-synthetics would include all fluids? Of course, one is, of course, what, common sense. We always say liquor in coffee. Would you like to have just the liquor, or would you like the liquor with some warm water? They ask you all the time when you go down to Bangalore or when you go to Chennai. But they'll ask even the Attorney General whether he'll have some liquor, you see. But is there something more substantial we are missing to show that liquor would mean all fluids?
Well,
I mean, that was the conventional meaning.
So,
forget Balsara.
So your lordships will have volume 1I. I have put all the dictionary meanings of all the dictionaries of the relevant time. The ones I could find. 1I.
Page?
It's page 1. PDF page 2. The first one is the Law Lexicon of British India 1940. What was prevalent in British India at the time? Well, I've taken the liberty of putting it all in one place. Liquor, a liquid or fluid substance.
Volume 1.
1I. I for India.
1.
There are two meanings possible. The
In
second,
a more limited sense.
That's
and
right.
it's more common application.
So there were-
Spirituous fluids.
correct. Your option is absolutely right. So there were two possible meanings, but this meaning which was there of liquid has always been there at the relevant time. And my submission is that liquor used in entry 8 is in the broader sense, which was prevalent at the time. It was a usage available at the relevant time. Today, if your lordships will go to dictionaries, just even if your lordships Wikipedia it, liquor equal to fluid bracket, it will say obsolete. Because nobody today uses. And we should not use our contemporaneous understanding of the word liquor and impose it on 1950s, my respectful submission.
It talks about spirituous,
Also,
not virtuous.
Virtuous, I also say exactly what it struck me.
That's right.
So spirituous and not virtuous.
let's kindly have Webster's number 2. Liquor, a liquid substance, and then again, the examples are, it's also used in the second context of a alcoholic drinkable fluid, but it's also used as a fluid per se. And if your lordships will go down to the etymology of it, liquor effectively is from Greek, which means fluid. Sorry, Latin, which is essentially fluid. That's the true pure meaning of liquor. Now, obviously, that meaning has evolved, but my respectful submission to the court is at the relevant time, one of the predominant meanings, or possibly the predominant meaning, was any fluid.
But then do we interpret the Constitution in terms of its original understanding, or have we understand it?
I'm so grateful. So, that's why I began by framing my argument as the semantic meaning. Your lordships will examine the semantic meaning. I'm not proposing an originalist understanding of the Constitution. That's never been our jurisprudence anyways. But to begin with, my lords, your lordships will always examine the semantic meaning as it existed. Then your lordships, after having determined what the original semantic meaning was, expand it if necessary, change it if necessary. What synthetics does, it mixes up, it says language has changed, therefore I'll now superimpose that on 1950. For instance, my lords, sex does not include sexual orientation. Your lordships have included it. But your lordships did not say sex originally included sexual orientation through expansionist process. Your lordships did not change the semantic meaning. It remains intact. Your lordship says situation has changed, society has changed, therefore we will now bring this into. What the synthetics code does, it changes the semantic meaning. That's what I was reading at 74. It says experience has changed, liquor today means this, therefore this is what it is. But that, in my respectful submission, is not permissible. It is nobody's case that something has changed. So the liquor original meaning is any fluid. The constitutional originally envisaged any fluid, and today's situation has changed so that we need to bring in something else. That's not the way. They said the language has changed, and I'll place something on that. Well, there's a very good article by a Yale law professor, because in US, in Article 4 of their constitution, they use the word domestic violence.
Domestic?
Violence. That's actually internal disturbance. But in 1780s, the word domestic violence was in vogue. What they mean is internal emergency. Today we will associate domestic violence with spousal abuse. So the meaning of the word, your lordships will first determine what liquor meant then, what intoxicating liquor meant then, and then after that semantic meaning is clear, your lordships will interpret it further if necessary. That the synthetics court has not done.
By the way, Mr. Parasat, where did you get all these dictionaries as of 1950 from?
I am grateful to the court. Actually, I use the judges' court library. Nowadays, they permit us. So, yes, last 2 days, my colleagues went to the library and we could access it from there. So, I'm really grateful to the court for that. So, your lordships will see. So, the meanings 3 and 4 are also there. Then what, if your lordships will stay on this, kindly have page 3. PDF page 4. Borrowing from justice.
I passed.
First, we'll have PDF 4 of the same volume. As I've tried to borrow from Justice Hidayatullah's concentric circle in the context of public order, national security, public order, law and order. And in my respectful submission, in our case, liquor is the biggest outside circle, which includes all fluids. Within that, you have intoxicating liquor, which is all fluids which contain alcohol. And within that, the smallest circle is alcoholic liquor or intoxicating liquor fit for human consumption. Now, what, my lords, the synthetics court has done, it has gone from liquor to really intoxicating liquor for human consumption. That middle thing has been missed out. So that's why I'm saying, how do we, if your lordships take a meaning of liquor, then your lordships will see what does it really qualify the word intoxicating. And then what is the effect of that? The effect of that is, let's say, denatured spirit. What is troubling the court? It really is one thing which comes out of it. So for everything else, it's covered in entry 8. There is no other substantive entry for denatured spirit or alcohol. So that's the only thing which is plucked out suddenly and hangs in the general entry of industry. Why should that be the case, I ask myself. Especially if at the time when the constitution was enacted, one of the known accepted meanings of liquor was fluid, and intoxicating liquor does mean clearly that anything which contains alcohol.
In fact, the argument of denatured spirit is by the states. Balbir Singh was appearing for Maharashtra, because the argument is because even denatured spirit is capable of being renatured in certain cases. Therefore, give us that power as states to ensure that there is no such abuse.
I'm grateful. So that supports my point, because it's not as if denatured spirit is a category which is independent and not interchangeable. That's all the more reason your lordships will give intoxicating interpretation which will include all alcoholic liquor.
All right, what else?
Well, just finally on that, the next is this article by your lordship's question, the Chief Justice's question on we are not At your Lordship, will I just pay?
Suppose for a moment, just to test it, you don't accept this submission of yours. Can we not reach the same conclusion by saying that, look, assuming therefore that denatured spirit goes into IDRA, unless there's a notified order, the state's power under entry 33 is not taken away.
No, but
It will arrive at the same conclusion, but
one
tomorrow the
can-
difference is Government of India can come out with a notified order.
much inferior
But they have
power.
not done it for the last, they'll not do it because it has not done it.
No, that's true. They have not done
India
it.
has,
That's a
India has
very.
also changed. I mean, there's nothing so great about industrial alcohol that the government has to regulate.
It's quite clear. It's possible they may not do it, but the nature of the power itself is different because this is constitutionally demarcated to me if I have it in entry 8.
That is dependent
Whereas then
on-
I'm dependent on their goodwill. I mean, that's really so. As a state, Malad, I would press your lordships to bring it in that. Although immediately it may not impact me even if it comes there, but then later on they can obviously bring in something, notify something, and I'm ousted.
I know, but also, you know, now you have to also understand IDRA itself is an anachronism. It's just survived, that's all. IDRA is one of those, it's one of those, you know, license Raj acts, which has also the scope of the act has been reduced now. There's no expansion of IDRA entries. What remained has remained.
Well, that's quite true, but Malad, in
It's
the
like
post,
the controller of capital issues. It was a time when, you know, when everything was so tightly regulated.
Effectively being monitored.
Yeah, of course.
It's not just an RPF law. There is a separate ministry,
Ministry.
under Ministry of Commerce, separate,
Malad, I will only.
But Mr. Solicitor, what we are saying is IDRA is now not, we are not today in a stage of the economy where IDRA is being progressively expanded. It's now
broadly, your lordships are on a broad,
on where the economy is going.
yes.
Malad, I'll just say one thing in response to that, that Malad, in the post GST era, for the states, any available spaces
Are important.
are important. So Malad, that's why we would press in entry because most of those spaces have been given up.
All right, thanks.
Well, just one on that, just so that to elaborate, your lordships will have the article at page 4. And I'm just going to read one page out of it. This is by a Yale professor, Jack M. Balkin, constitutional law professor. It actually just states what our legal position in India, any event is. I mean, of course, in US, originalism is very expansive. We don't subscribe to it at all in that sense. But we do subscribe to it in the way he frames it, is my respectful submission. And your lordships will kindly have PDF page 8.
Which volume is it?
Well, this is 1I,
One eye. Same.
same volume.
You have to read.
It begins, my lords, PDF page 8 with the first line, but fidelity. My lords have it. Regular page
Yes.
7, PDF page 8. But fidelity to original meaning does not require fidelity to original expected application. Original expected application is merely evidence of how to apply text and principle. Each generation is charged with the obligation to flesh out and implement text and principle in their own time. They do this through building political institutions, passing legislation, creating precedents, both judicial and non-judicial. Thus, the method of text and principle is a version of framework originalism, and it views living constitutionalism as a process of permissible constitutional construction. The term original meaning can be confusing because we use meaning to refer to at least 5 different things: semantic content, practical applications, purposes of functions, specific intentions, as associations. Thus, when we ask the meaning of equal protection clause, we could be asking what concepts the word in clause 1, clause point 2, how to apply the clause, the purpose or function of the clause, the specific intention behind the clause, or what the clause is associated with in our minds or more generally in our culture. Fidelity to the original meaning in constitutional interpretation refers only to the first of these types of meaning, the semantic content of the words in the clause. We follow the original meaning of words in order to preserve the Constitution's legal meaning over time as required by the rule of law. Otherwise, if the dictionary definitions of word change over time, their legal effect would also change, not because of any conscious act of lawmaking or even political mobilization, but merely because of changes in language. And this is the example. So for example, when Article 4 says United States must protect the states from domestic violence, we should employ the original meaning riots or insurrections, not the contemporary meaning of spousal assault. So I will conclude by saying that your lordships will examine first what the original meaning of liquor in 1950 was. And then we'll see what is the qualification which intoxicating offers. In our respectful submission, it contains the entire universe. And not just until 1990, right from 1873, when the first Bombay Act was passed, that's the earliest act, till 1990, even denatured alcohol is clearly included in intoxicating. Till 1990, synthetic judgment, plus denatured alcohol is in effect included in intoxicating liquor. It's only synthetics definition which takes it a changed view based on the change in what intoxicating liquor means in society. So it is not as if it's something new to us. That was the meaning which prevailed from 1873. All Mr. Dwivedi showed your lordships from all those acts. The meanings was quite clear. It included everything, including denatured alcohol.
Thank you.
I'm extremely grateful.
Thanks.
Volume 1B,
For
appealing for the intervener in IA number 237338 of 2023. Private individual
who's
party.
the intervener?
Pardon, sir?
Who's the intervener? Last time you told us you are the intervener.
No, sir. I am not the intervener.
No, last time.
Party,
His daughter was the intervener.
that is the private individual party, citizen of India and the resident of Uttar Pradesh. Miss Sheila.
Miss
Sheila Sharma.
Sheila Sharma.
Yeah.
Is she a teetotaler?
Pardon?
Is she a teetotaler? She must have locus standi.
Yeah,
First.
yeah, sir. Well, Lordship, I have the locus.
Teetotaler means chai ही पीते हैं.
Pardon?
Teetotaler means chai ही पीते हैं.
Sir, can I start?
Yes.
How she is affected by the issue involved?
Pardon, sir?
How she is affected by the issue involved?
Yes, sir. We are talking about the industrial alcohol. And this industrial alcohol is many times for the direct human consumption. And I give the example, like in the cosmetic industry, the nail polish.
People drink clean water.
No, sir. Human consumption, when we using the nail polish, then it comes in the direct contact of the skin, and it is also the human consumption. We are wearing this cloth, it is also the human consumption. How can we say if we eat or drink anything, then it is the human consumption? The constitutional entry mention the word only the human consumption. That is not saying that we should eat, we should drink. So that's why, sir. Can I start?
Thought you were done and you made the point.
No, Learned Counsel, I thought you have completed.
No, sir.
So human
Only I am explaining my locus.
So human consumption doesn't necessarily mean that you have to eat or drink the product.
Yeah, sir,
Then-
absolutely. So
Yeah.
can I start?
Yes.
The main issue is the interpretation of the section 18G of the Industry Development and Regulation Act 1951 with regard to state legislative power for the industrial alcohol. This is the main issue in this matter. So on the last page of my written submission, the last paragraph, I will read only four lines, and after that I will say anything. mere existence of Section 18G of 1951 IDR Act in the statute cannot out the competence of the state legislature to enact the legislation in respect of the matters falling under entry 33 of the list 3 of the 7th schedule to the Constitution. States' power to regulate the use of alcohol, which would include the power to make the provision to prevent or check industrial alcohol being used as intoxicant liquor, should be recognized. So, sir, we are talking here, this is the industrial alcohol. This is the non-industrial alcohol. But there is no way the clear-cut division. Denatured alcohol, intoxicating liquor, as I said previously, is also for the human consumption. Like, sir, Lordship, in this courtroom, we use the spit polish. We use the spit polish on the wooden walls. In this spit polish, when we sit on the dais, we direct, you can say, in the skin. So that's why, how can we say many products of the denatured spit directly in the human consumption and some indirectly in the human consumption. That is the way. And also,
What is your,
pardon,
what is your name?
Dr. Vivek Sharma, sir.
So Dr. Vivek Sharma, you are saying that ये जो लिकर की बात हो रही है,
Yeah.
इसके लिप्स के साथ कोई संबंध नहीं है ना? यही कहना चाहते हैं, कंजम्पशन माने लिप्स के साथ संबंध नहीं है,
Absolutely, sir.
है ना?
Absolutely.
समझ गया हम लोग.
The things are overlapping, not the clear-cut division of the human consumption.
Sharma ji, is the intervener also related to you or no?
No, no, sir.
Just the name is the same.
Yeah, yes, absolutely.
That's your idea.
And, sir, with regard to entry 8,
Last point.
last point, with regard to entry 8, when we are talking about the intoxicating liquor, many times before 70s and 80s, we can see in the labs the spit lamp in the laboratories are used, and also nowadays also in the schools going children can use that. Many lecturers of that time and the students directly drink that.
Directly drink what?
The intoxicating liquid denatured spit, which are using to light the spit lamp. So that's why there can be no clear-cut demarcation. All the things are overlapping. Because, sir, at that time in the village and the small towns, schools are available, but not the shops of the liquor.
Yes.
Can I start, sir?
It's not a hop, skip and start, you know.
You came to the last para of your
Yeah, yeah.
submissions now.
It is over.
Now we have completed. Now, thank you.
I am
Thank
like
you.
concluding.
Thank you.
Ah.
Thank you,
Cool.
Mr. Chandra. Mr. Attorney General.